Welcome to Dorsey & Whitney's Creative Industries Group webinar on Video Game Law 2020 Year in Review. I'd like to introduce Sarah Robertson, a partner and our New York Trademark Department Head. Sarah, take it away.
Thank you, Sean. Welcome, everybody. My name is Sarah Robertson. I'm based in Dorsey's New York office and the co-chair of the Creative Industries Group at the firm. I practice in the IP and digital media area. I'm happy to act as moderator today for our video game law program, which is covering legal developments in the year 2020. With the current stay-at-home environment, the video game environment's seen double-digit growth, and IP issues and contractual issues have come to the forefront. We're happy to give some information today on those. Just as a housekeeping matter, we have a lot of content to cover. The program today is 60 minutes long, and you'll see some information on screen and in your confirmation about CLE forms, as well as the materials that will be sent after the fact. Because of the number of participants today and the volume of content, we're going to hold questions until the end. We're going to leave a 10-minute sort of official Q&A session, although both of my colleagues and speakers, whom I'll introduce in a minute, are willing to stay on the line and field questions after the program is over. So please feel free to stay on us a 60-minute time frame. With that, I'm happy to introduce my two colleagues, Ryan Meyer and Stefan Szpajda, who are in the Seattle office, opposite coast from me, both practicing in our IP litigation group and providing counseling work as well as licensing expertise, and who have a lot to share with you today about legal developments. With that, I'll turn over the floor to Ryan.
Hello, everyone. Thank you very much for attending. My name is Ryan Meyer, and I'll start today's presentation talking about some case law relating to depicting reality in video games. So as we all know, much of the world is covered by someone else's IP, and it's not just out there for the taking. But as technology has advanced and computers and game consoles have become better and better at creating virtual versions of the real world, many games have focused on realism as a way to be more believable and immersive. For example, sports games involving real athletes want the athletes in their game to look like the actual players. War games involving modern or historical events, equipment, location, etc., want to depict everything accurately. This sets up a tension between protecting IP, but while permitting game companies to still accurately depict the real world. One area where this comes up is tattoos. Now, tattoos are protected by copyright. Copyright protection subsists in original works of authorship fixed in any tangible medium of expression. Tattoos are frequently original works. They are authored by someone, generally the tattoo artist. They are fixed in the dermis, which is a deeper layer of skin, and the dermis is a tangible medium. Now, most people would intuitively assume that when you get a tattoo, you own that tattoo design, but that's generally not the case. Whoever designed that tattoo, usually the artist, or whoever purchased or licensed the copyrights to that design, are the owners of that tattoo, usually not the person sporting the tattoo. This means that when a video game realistically depicts an actual person who has a tattoo, we end up in this sort of situation. And the two cases I'm going to talk about fall right in the area where all these circles join. So the first case, Alexander versus Take-Two Interactive. The plaintiff is Catherine Alexander, who is a tattoo artist, and she inked 6 tattoos on the back and the arms of a professional wrestler, Randy Orton, and lived to tell the tale. And here's a picture of Orton. I don't know if these are these are his tattoos, but I don't know if these were the ones particularly inked by Alexander. And then the defendants are the World Wrestling Entertainment Group, which is Orton's Wrestling League, Take-Two Interactive Software, which is the developer and publisher of the WWE game featuring Orton, as well as other entities associated with developing and publishing that video game. Alexander filed a copyright infringement complaint asserting that the defendants had infringed her rights as to all 6 tattoos. So initially, the defendants moved to dismiss, and they were denied as to 5 of the registered designs. But as to the 6th design, the court dismissed it because it was a Bible verse, and that the Copyright Office Register had rejected when Alexander applied for protection for it because it lacked the required authorship. Now, as far as I can tell, this is probably because this was simply a Bible verse written out without any extra creativity really added by Alexander. But regardless, it was dismissed, not part of the case. So next, defendants move for summary judgment on 3 affirmative defenses: implied license, fair use, and de minimis use. Now, the court found that the implied license and fair use defenses had genuine issues of material fact that needed to be resolved and precluded summary judgment. Interestingly, the court found that there was no authority showing that de minimis use was even a viable defense in the Seventh Circuit, and so it denied the de minimis use defense on that ground, and also on the ground that the defendants had copied the tattoos in their entirety rather than just a fraction of them. At the same time, Alexander had moved for summary judgment as to copying, and this was granted because there was no real dispute that the defendants had accurately depicted Orton's tattoos in the WWE game. This case has been delayed due to the pandemic, but it's still pending, and it probably won't have a resolution until maybe the fall or winter. Moving to the second tattoo case, this one involves a plaintiff, Solid Oak, which is a company that exclusively licensed tattoo designs inked on 3 NBA players: Eric Bledsoe, LeBron James, and Kenyon Martin. Solid Oak differs from Alexander in that in Alexander, the plaintiff was the actual tattoo artist and designer. Here, Solid Oak didn't ink the tattoos, didn't create the designs, they merely licensed them. So the defendants are 2K Games and once again Take-Two Interactive, and they are the developer and publisher of an NBA 2K series of video games that accurately depicts NBA players, including the 3 listed above. Solid Oak sued them for copyright infringement. They tried unsuccessfully to get the claims dismissed twice, but the 3rd time was the charm when they filed a motion for summary judgment on essentially the same grounds as in Alexander. However, despite the similarities between the facts of Solid Oaks and Alexander, a different court in a different circuit rendered a different result. For example, the defendant's use was found to be de minimis, which is a viable defense in the Second Circuit. And the reason is there are a lot of players in these NBA 2K games, only 3 of which have the tattoos at issue. And so in the average game, it's rare that one would even see one of those players, let alone their tattoos. And when you do see the tattoos, they're very, very small and often distorted due to movement, lighting, etc. The court also found that the tattoo artist had granted an implied license to the players. The tattoo artist knew who the players were, knew that that the tattoos were displayed in a place where they would be shown when they were playing games on TV or in other media. So the court found that there was an implied license, and that implied license included a sublicense to when the players licensed their likenesses to someone, such as for the NBA 2K game. This included the right to depict them with their tattoos. Also, the court noted that the artists didn't attempt to limit these licenses, and they were granted before being licensed to Solid Oak. The court also found that these tattoo designs were protected by fair use. They were used to accurately depict players, not as a self-expression through body art, so the use was transformative. They were relatively rare in the game and hard to recognize, so they were at best incidental to commercial value of the game. Also, the tattoo artists themselves testified that the designs weren't that original. Most of them only had common tattoo motifs or were copied from images the artist did not create, such as photographs. And finally, the court found that the defendant's use was unlikely to impact any market for the tattoos. Now, I've included one more case in this section that isn't actually a copyright case or a tattoo case, but it does relate to the idea that if the motivation to include realism is based on authenticity or wanting to be realistic, that's often a good basis for a defense to IP infringement. So in this case, AM General is the owner of the trademark to the Humvee, which is a vehicle all of us are probably familiar with, and it's often used by the US in combat situations. And it's also used without authorization by Activision Blizzard in its Call of Duty video game, which is meant to be a realistic simulation of modern warfare. And for that reason, in part due to for that reason, the court granted summary judgment to Activision on all of AM General's claims, finding that because of the artistic value, if they didn't include the Humvee, they wouldn't be able to create a realistic sort of simulation of modern warfare. So for takeaways from this section, realize that different circuits have different rules and may recognize or not recognize certain defenses. And game companies who are facing similar claims should emphasize certain points, like the insignificance of their use, the fact that the context suggests an implied license, the motivation for realism and authenticity necessitates use of the work. And also look for any chances to argue that the design is not original, it's just a common motif, or it's a copy of someone else's work. Moving from tattoos to iconic dances, the next case is Pellegrino versus Epic Games. And in this case, Leo Pellegrino is a professional saxophone player and a member of the brass house band Too Many Zoos. He is famous for creating and performing a move referred to as his signature move when he's performing while playing the saxophone. And here the defendant is a major game company, Epic Games, that develops and publishes the popular free-to-play multiplayer online battle royale game Fortnite, which is about sort of a last team standing fighting game. And if you're not familiar with Fortnite, ask your kids because they may very well be playing it. So even though Fortnite is free to play, Epic generates revenue through Fortnite by selling in-game items, one of which is called an emote. An emote allows a player to have their character perform a particular gesture or dance move. And one of these emotes is called Phone It In, and that's the emote issue in this case. Now, bear with me for just one moment. Okay. On the left, you will see Leo Pellegrino doing his signature move. On the right, you'll see a Fortnite avatar doing Phone It In, and they do look similar. So Pellegrino sued Epic for a variety of common law and Lanham Act claims, and Epic moved to dismiss all claims. And in fact, all claims were dismissed except for Pellegrino's false endorsement claim. Now we have more content than time, so I'm going to not necessarily hit every bullet, but you are welcome to ask questions about them after the presentation. So first, I'll talk about publicity and privacy claims, which Epic moved to dismiss on First Amendment grounds. Third Circuit courts weigh whether celebrities' likeness is so transformed that it has become primarily the defendant's own expression when deciding between First Amendment protections and publicity and privacy rights. And that's called the transformative use test. So here, Judge Padova dismissed Pellegrino's claims because Fortnite's avatars are very customizable, and they seldom look anything like Pellegrino or have any of his biographical information. Moreover, Phone It In is executed in the context of a battle game, not a musical performance. So perhaps the judge's decision could have gone a different way had this been a game like Rock Band, where the player's character is a musician. That wasn't the case here. Then moving on to the state trademark infringement claim. Here, the court found that this claim was preempted by the Copyright Act because the signature move is a dance, which falls under the general subject matter of choreographic works, which are specifically covered by the Copyright Act. And the state trademark claim was essentially equivalent to a copyright claim and therefore was preempted. Moving next, I'm going to skip down to false designation of origin claim. The court found that this claim was barred by the Supreme Court decision Daystar which held that false designation covers the origin of the good itself here being Phone It In. Not the idea, concept, or communication embodied in those goods, such as the signature move, which would fall under copyright law. Pellegrino did not plausibly allege confusion as to who produced it or who produced Phone It In, so that claim was dismissed. False endorsement was the one surviving claim, and under the motion to dismiss standard, Judge Padova assumed all the allegations were true, and Pellegrino had alleged that the signature move was identified with him, that it was immediately recognized by many Fortnite players, that Epic had intentionally copied it, that the name Phone It In even alludes to a 2017 phone commercial featuring Pellegrino. And the court also found that the false endorsement claim was distinct from the false designation of origin claim because the allegations related to confusion over endorsement, not the origin of the signature move or Phone It In. So with one surviving claim, 1 month later, Pellegrino dismissed that claim without explanation, and that ended his case. In the next case, we'll talk about Brantly versus Epic Games. Same defendant, Epic, same game, Fortnite, and emotes again, but this time the emote is Running Man. And the plaintiffs are Jalen Brantly and Jared Nickens, who performed and popularized this dance when they performed it during breaks at the University of Maryland basketball games. And then they posted it and it went viral. And then they performed it on Ellen and it went more viral. And now they allege that it has become synonymous with them. And just a quick view of an avatar performing Running Man. And I give you my word that when Brantly and Nickens do it, it looks very similar. So Brantly and Nickens asserted essentially the same claims as Pellegrino had asserted against Epic, and with the same result. In fact, Judge Paul Grimm repeatedly cited Pellegrino. The big difference is, whereas in Pellegrino, the false endorsement claim survived a motion to dismiss. Here it did not. And the reason really is, whereas in Pellegrino, the allegations related to endorsement and giving a false impression of endorsement rather than confusion about the origin of the signature move or phone it in. Here, the endorsement claim was conclusory. They had alleged copying, and they had alleged that Epic used their likenesses, but according to the court, this was insufficient to plausibly allege a false endorsement claim. So takeaways here: if you plan to borrow a celebrity's signature move for your game or other medium, make sure that it's sufficiently transformative. For example, change the context to something different, make sure the character looks different from the celebrity, etc. And also, since copyright preemption played such a big role in these cases, in the future, I would look to maybe copyright claims being asserted where the facts permit instead of or in addition to Lanham Act and common law claims. And my last topic is video game cases in the time of COVID-19. And I'm going to talk about one decision from the Gree v. Supercell Oi litigations because it highlights some challenges facing modern video game companies during the pandemic. Now, one thing about the video game industry is it's becoming more and more global. And in this case, none of the parties involved were even from the US, which could create discovery issues without a pandemic, but they were exacerbated by the pandemic. So they were moving along fine. The pandemic began. They moved for the case and they extended the cases or the deadline once for COVID-19 reasons. Before that happened, Supercell had deposed some of Gree's 30v6 witnesses and inventor employees in Japan last February, but was dissatisfied with the results. And so they wanted some additional 30b1 depositions and 30b6 depositions on two additional allegedly newly identified issues. And they wanted them in Japan. Gree offered some alternative discovery instead, but Supercell refused. So Supercell moved for relief. Second, two motions. One was for an extension by 90 days due to the pandemic. One was an order for employees to be made available for depositions in Japan. Now, without going through all of these various points, Judge Payne essentially thought that the value of these additional depositions would be speculative and cumulative and didn't justify anything beyond the alternative avenues suggested by Gree. Moreover, what Supercell was asking was technically impossible, since at the time, Americans were not permitted to take depositions in Japan, and the judge's standing order even prohibited in-person depositions during the pandemic. So finally, I'm going to end on one last case, which is actually not in 2020. It's January 2021, but I'm going to mention it because it's the first patent jury trial held over Zoom and related to a video game controller. Here's an image taken from the patent, and the claims essentially cover the shape and configuration of the controller and its buttons so that it can be held in a particular way. So after a week-long trial, everyone generally agreed that it went smoothly despite everyone being remote, including the judge, the jurors, the counsel, and the witnesses. This might have been in part because the technology at issue was relatively simple, and it was something that could be sent to the individual jurors to hold in their hands and inspect while the trial was going on. If the technology had been something more complex or had been a process, there might have been a different story. So finally, some takeaways. Courts want to move cases along, even during in the midst of a global crisis. Take your discovery, especially your important discovery, as early as possible, since you never know what will happen in the future. Be flexible about alternative discovery methods, or you might not get all the discovery you want. And finally, under the right conditions, even a jury trial can be conducted effectively and efficiently over Zoom. Thanks very much.
Thank you, Ryan. And with that, we'll shift over to Stefan's portion of the presentation.
Hi, everybody. I'm going to be talking today about patent litigation as soon as I can get control of the screen here. All right, so patent litigation is obviously a big topic. We can't cover every aspect of it today, but I wanted to highlight a few issues that I thought were particularly important to the video game industry in 2020, and to highlight some general themes that I thought the cases that we saw in the video game industry might tease out for us. So before kind of jumping into that, I thought I'd level set a little bit and give everybody a little bit of context for what was happening in patent litigation generally in the country. And so, 2020 saw an uptick in new patent litigation filings relative to the past couple of years. So the market was strong. We saw a lot of the same action in the jurisdictions that we've seen in the prior years. So Delaware, Texas, California remained the most popular venues. There's been a surprising, perhaps not surprising, but a recent rise in filings in the Western District of Texas, kind of taking over the Eastern District of Texas. So that's a relatively new shift. But otherwise, those jurisdictions have held steady over the years. Two of the big themes that emerged in 2020 that I want to hit on, because they also dovetail with what's been going on in the video game industry, is continued uncertainty around developments in Section 101 and how that affects patent owners as well as defendants in patent litigations, as well as continued signs of strong regional variation in the outcomes, both as to Section 101 litigation and other patent-specific issues. Video game companies also were regularly involved in these litigations in 2020, both as plaintiffs and defendants. And so I'm going to highlight some of those cases, both from the perspective of the plaintiffs and the defendants. One of the themes I want to talk about today is Section 101. And if you've ever dealt with patent litigation, you've probably heard of the concept. If you haven't, you may not be familiar with it. So I'm going to try to give a very quick introduction to what this means so that everybody's at least able to follow along. So Section 101 of the Patent Act is the section of the act that governs eligibility for patent protection. So not every idea that you can think of is eligible for patent protection, and Section 101 provides very loose parameters on what is and is not eligible. Up until about 2014, this was not an issue that was heavily litigated. But everything changed in 2014 when the Supreme Court decided Alice, which was a major shift in how defendants thought of claims asserted against them, because it gave them essentially a new defense. It wasn't technically a new defense, but for all intents and purposes, it emerged as a new defense because of how it allowed patent defendants to assert that claims asserted against them were, in fact, not eligible for patent protection, and it gave them a streamlined path to get out of those litigations early on in the process. So what the Supreme Court attempted to do in Alice was define a two-step process that would allow courts to determine whether a claim was, in fact, eligible for patent protection when it concerned an abstract idea. So abstract idea can mean a variety of different things, but most of the time it relates to software. So that's how it most often affects the video game industry anyway. So if a claim is directed to software, under step one of Alice, it's considered an abstract idea much of the time. There are, of course, exceptions, but we won't have time to go into all of them today. Under Alice, the court is then instructed to look at step two, which is to determine whether the claim is directed towards an inventive concept, essentially whether there's something about the claim that goes beyond just using generic computer components to execute software. And if there isn't such an inventive concept, then that claim can be deemed ineligible under Section 101, and this can result in that claim being invalidated and no longer subject to a lawsuit. So this is a very attractive case from a defendant's perspective, because it allows defendants to get out of cases cheaply and quickly in a way that was simply not available before. Conversely, if you're a patent owner, this was sort of a nightmare because it allowed defendants to invalidate your patents with a very low investment compared to the past years. So to give you a sense of how big of a deal this was, from July 2014 until June 2019, there were over 800 federal court decisions on various Section 101 motions, and the ineligibility rate hovered at around 62%. Of those, 156 of those decisions were made by the Federal Circuit, which is the appellate court that deals with patent litigations, and there the ineligibility rate was 86%. So you can see that from the perspective of a patent owner, this was a bit of a disaster. However, if you were a defendant, this was a great opportunity to get out of cases cheaply. There's also strong regional variation. As you can see in Texas, the ineligibility rate was quite a bit lower than even in Delaware. And if you compare it to New York or Washington State, where the ineligibility rates were over 80%, you start to see that this concept of regional variation is really important, because if you're choosing where to file a patent suit and you're concerned about Section 101, you would much rather be in Texas than in Washington. Conversely, if you're sued in Texas and you think that the claims have some vulnerability under Section 101, you have a strong incentive to try to transfer that case over to Washington or New York if you can. Now, part of the story of Section 101 is there's been a clear downward trajectory in the success of these motions. The overall ineligibility rate was initially at around 75%, and over a period of a few years, it dipped down to 50%. So there's a variety of reasons people speculated for that, including, just over time, patent owners get smarter about which claims to assert. But part of this is also a function of decisions the Federal Circuit made in 2018 and 2019 that increase the scrutiny that courts are supposed to apply to the factual allegations in a complaint, making it harder to dismiss a complaint early in the action. And it gave more credence to factual allegations, specifically under Step 2 of ALICE, under the inventive step analysis. So these three decisions, I'm not going to go into them today, but I'm flashing them here for your reference, changed the landscape as well somewhat and made it harder for defendants to assert that a claim is ineligible for patent protection early on in litigation. This is here for background. I'm not going to go into what all this means, but it really shows that in Celspin, the Federal Circuit guided lower courts to pay attention not to the specification of a patent, but specifically to the claims, and not to allow patent owners to simply point to the specification to assert that there's a factual dispute that supports eligibility, but rather to pay careful attention to the claim. So patent litigators may know what that means, but it's mostly there for reference. So I wanted to give a couple concrete examples from the video game industry in 2020 that illustrate some of these themes that I've just introduced. One of them here is Ubisoft versus Usician, a case that was pending in North Carolina and ended up going up on appeal to the Federal Circuit. So this case was striking for a couple different reasons. One of them was that the Federal Circuit affirmed an ineligibility finding on a Rule 12b6 motion. And that runs counter to the theme I was just introducing, which is now under Berkheimer, Atrix, and Celspin, it's supposed to be harder to do that. But nonetheless, this shows that the Federal Circuit will still affirm a finding of ineligibility that was made on a motion to dismiss. And the court did so by applying the standard two-step ALICE process, finding that the claims were abstract and did not have an inventive concept. The claims in this case, by the way, were directed to a digital guitar instruction platform that helped teach how to play guitar. And so this was using software to teach somebody to play guitar. The court found that to be abstract because you were simply taking a concept that existed in the real world and applying it to software without adding anything inventive in the process. And so that caused the court to find that this was ineligible because it was simply using conventional techniques to teach an abstract idea. One of the things that was striking about this as well is that Ubisoft specifically argued that there should have been a greater focus on its factual allegations in the complaint in an attempt to appeal to the reasoning from Berkheimer, Atrix, and Celspin. But the Federal Circuit rejected this argument, saying that it is not required to accept Ubisoft's unreasoned conclusions and arguments in the absence of specific plausible allegations of supporting facts. So this is really good news from the perspective of defendants because it gives you, it puts the scrutiny on the claims, and it doesn't simply allow patent owners to add anything they want to a complaint and hope to survive a motion to dismiss. Now, again, conversely, from Ubisoft's perspective, this is bad news because it means that some subset of their patent portfolio is not as valuable as it was before this decision because it will not survive court scrutiny. And so the lesson here really is that if you're going to be asserting claims in patent litigation at this point, if you have a patent portfolio, take a look at the current state of the Section 101 jurisprudence. It's constantly evolving. And you want to make sure that the way that you select your claims for assertion in patent litigation is responsive to the changes that have been happening in the court decisions interpreting Section 101. It's also striking because it shows that Ubisoft, which is one of the largest developers in the world, has a patent portfolio that it's willing to assert in litigation. We're used to thinking of video game companies as defendants in these actions, but they'll often, or at least occasionally, assert their patents as well. And so that's important to pay attention to as well. Another case that dealt with Section 101 in the video game context was Barbaro versus Niantic. Niantic, of course, makes the famous Pokemon game. And this concerned a patent that was directed to the interactive virtual thematic environments that can be generated by converting real-world images into virtual images. And so, in other words, if you've played Pokemon, you walk around in an interactive environment that really tracks the real world. It's just based on real maps. And so, this was another case that was decided on a Section 101 motion, this time under Rule 12C, which for the litigators, you'll know that Rule 12C is very similar to Rule 12B6 in the sense that it has the same legal standard. It's a rule on the pleadings as a matter of law, but it does not come at the same stage in the process usually. It happens after an answer has been filed. And in this case, actually, Niantic brought its Section 101 motion after the district court's order on claim construction. So litigation had actually been ongoing, I think, for a couple of years by the time they filed this motion. And so because of Berkheimer and Atrix, Barbaro argued that actually this was an inappropriate procedural move, that Niantic should not be permitted to challenge eligibility under 101. The district court rejected that argument and said courts can and regularly do decide the issue of 101 invalidity on Rule 12C motions. And so the fact that there are factual dispute that exists does not render that improper. So this is an interesting attempt by a patent owner to try to really take a strong read of Berkheimer and Atrix and Seltzman and attempt to argue that these cases prevent early and law-based determinations of ineligibility, but the court rejected that and really kind of ran in the opposite direction and found the claims ineligible. One of the reasons that may have been proper here is because that Rule 12C motion was brought after claim construction. So if you're a defendant in one of these actions, you can consider bringing a 12C motion after claim construction to improve your odds of success in light of Berkheimer and Atrix. So again, this just illustrates that the court applied steps 1 and 2 of Alice and found that the claims were abstract because they were directed to simply taking any combination of generic components and generating a virtual environment from that. And there was nothing special about the way in which the claims were ordered and nothing recited in the claims that rendered them inventive under this standard. So here I thought it would be helpful to pause for a moment and actually show you one of these claims. This is from that Barbaro-Niantic case that illustrates sort of what the court was looking at when it determined that the claim was ineligible. And then I'm going to contrast it with another claim that was held to be eligible. So you can see here, this is a pretty standard software-oriented claim. And I've highlighted in red here some of the key components, some of the generic components of a computer that are recited in the claim. There's memory, there's a step of retrieving information from that memory, of integrating that information into a three-dimensional virtual environment, and using a processor to run the program. There's other words here, obviously, but the bottom line is these claims are very clearly directed at generic computer components and using those computer components to create a virtual environment. Now, before 2014, most people would not have bothered to file a motion challenging the eligibility of this claim because there was not a good basis to do so. But this is precisely the kind of claim that these days is much more vulnerable to ineligibility in light of all the movement we've seen since Alice. I've also included some additional reasoning from the court's opinion here. I'm not going to go through all the points, but if you're interested in sort of how courts think about distinguishing the sometimes conflicting Federal Circuit precedent on this issue, I urge you to take a look because this case kind of walks through and makes some interesting distinctions from prior decisions. Like Ubisoft, this case is a reminder that developers who maintain patent portfolios need to pay careful attention to how their claims are drafted. They want to make sure that their claims are being drafted in light of developments in Section 101 case law. And when they're choosing a claim to assert or defend against, they should really be thinking about, well, if this is a software claim, do I have a good argument for a Section 101 ineligibility motion? A third case from the video game context that addressed this issue had a different result, and I want to kind of compare it a little bit with the last one to show you why that may have been. So this is a Savvy Dog versus Pennsylvania Coin. Savvy Dog is a game developer that does essentially gambling games, and that's an important market segment in the video game industry, as you may know. And in this case, the particular game they developed addressed a problem that exists in some states where you can have gambling games as long as there's some skill-based amusement, but it can't be a pure game of chance. And so Savvy Dog determined that they could create a preview display in their games that allowed a user of that game to introduce an element of skill to the game, so that it wasn't a pure game of chance, and that would allow those games to be playable in states that have regulations that prevent pure games of chance. And so here the court looked at the claim and said, although it's abstract because it is a way of playing a game under step one of Alice, there was in fact an inventive concept because there was at least a factual dispute over whether or not the game processor improved on earlier processors, and that generated a question of fact that made it so that the court would not rule as a matter of law on illegibility. So I wanted to highlight here what the claim looked like in Savvy Dog to show you some of the differences from the Niantic case and why the court may have come out differently here. So although you see this a similar recitation of elements that you would have seen in the Niantic case, a lot of generic computer components, the claims themselves recite steps in using those components in a way that the court considered inventive, because they're all directed to generating that preview display that allows a user to engage with the screen prior to beginning the game and creates an element of skill. That's recited specifically in the claims. It's not just factual arguments that the patent owner made in the complaint. It's not just in the specification. It's directly in the claims. And so the court can look at that and say, this may ultimately be ineligible, but I can't make this determination as a matter of law because I can look at the claims and what the patent owner is saying about the claims and decide that there's a factual dispute here. And so there was some elaboration on that in the opinion. The important thing here is that the court found that a complaint is only insufficient as a basis for a factual dispute if it is contradicted by the patent itself. And so sometimes defendants will try to argue that the complaint is not enough to create a factual dispute, and the court here is essentially saying that may be true, but it's only true if what the patent owner is saying is contradicted by the patent. If there's a factual allegation in the complaint and it's consistent with the patent, then that could in fact be a genuine factual dispute that would preclude a ruling on as a matter of law in Section 101. There's another opinion here that I wanted to flag. I'm not going to have time to walk through it all, but I wanted to include in my slides because it's such an important issue. This is Mcgraw versus Bandai. This goes a little deeper into how Section 101 of the Patent Act interacts with Section 112 of the Patent Act, which is another requirement. It sort of lays out certain requirements that patent claims have to have in order to be enforceable and valid. If you're interested in this topic, I urge you to flip through the slides and send me an email after. I'd be happy to talk to you about it. This is a really important decision. It's been going for years, and there was a second time it went up to the Federal Circuit in 2020. It really merits consideration if you have a patent portfolio that you want to make sure is enforceable, or if you're in some deep litigation and you're concerned about maybe 101 not being a good option, but you're considering asserting Section 112 issues in the claims. And so this is a good one to know about. We don't have time to cover it today though, so feel free to reach out about that one. Another issue I wanted to highlight today is some of the regional variation I've mentioned in patent litigation. So moving beyond Section 101, there are regional variations in the way that courts around the country interpret the patent laws, which some people may find surprising because it's a federal statute, and you would expect, and with a federal dedicated court of appeal, so you would assume that there would be uniformity. But the reality is that there's a lot of regional variation that's drawn from local practices, standing orders, certain dispositions of judges in those districts, and I thought that this Bot 8 versus Sony case really highlighted that point pretty well. So this is a memorable set of orders by Judge Alsop of the Northern District of California, in which he reprimanded Bot M8, which was a patent assertion entity that asserted some patents against Sony. And specifically the PlayStation 4 and several video games that are playable on the PlayStation 4. Judge Alsop reprimanded Bot M8 for its repeated failures to adequately allege infringement in the complaint. And so the facts here are, there's a lot going on in these decisions. I won't kind of lay out all the issues, but in brief, the Bot M8 sued Sony initially in the Southern District of New York, and then the matter was transferred to the Northern District of California. And upon transfer to the Northern District of California, Judge Alsop reviewed the complaint and decided that he thought it was inadequate and ordered Bot M8 to reverse engineer the PlayStation 4 before proceeding with its claims, which is an unusual step. And so this is actually from the transcript here from the case management conference that Judge Alsop scheduled, where he specifically said, if you can buy the product on the market and reverse engineer it, you have to do that before preparing your complaint. In fact, he said you have to do it with an expert. And he says, otherwise, I'm going to let them bring a motion to dismiss, and you can test it out in the federal circuit. So that shows Judge Alsop's trademark confidence and directness. It also shows a type of reasoning about the adequacy of pleading a patent complaint that does not necessarily track with what you might expect to see in Delaware or Texas. And so this, again, highlights that if you're a defendant and you have a basis to get into California and you want to play and you want to make sure that the plaintiff is playing by the rules, those rules are going to be much more onerous on the plaintiff in Judge Alsop's courts than they would be in other jurisdictions. And in the end, Judge Alsop dismissed 4 of the 6 patents from the case because Bot M8 failed to adequately plead infringement on an element-by-element basis. And with some rather strong words, Judge Alsop rejected the argument that the Digital Millennium Copyright Act actually prevented them from reverse engineering the PlayStation 4. So there was some really interesting background there that you can read about in those decisions that I've cited here. And in fact, Judge Alsop went so far to say that if Bot M8 wanted to file another amended complaint, they could do so on the condition that they would pay the fees and expenses incurred by defendants in responding to yet another amended complaint. So that's, again, not something you would likely see in many other jurisdictions. Another illustration of this regional variation that I've mentioned is highlighted here in a couple cases brought by Genuine Enabling Tech. They sued both Nintendo and Sony in separate actions on the same day in Delaware back in February of 2017. Nintendo then moved to transfer the case from Delaware to Washington in 2019, and then not too long after that moved for summary judgment of non-infringement and invalidity, and prevailed in the summer of 2020 as to non-infringement. And invalidity was actually not addressed by the court in the order, but nonetheless, July 30th, 2020, after transferring to the Western District of Washington, Nintendo got a win on non-infringement and defeated the action. In contrast, Sony did not move to transfer from Delaware. And so the local rules are different in Delaware. The timing of summary judgment motions is different. And so Sony requested leave to file early summary judgment motion on June of 2020, which is while the Nintendo motion was pending already. The Delaware court then denied that request in August of 2020. So I'm focusing on the dates here because you can see, I'll just go back for a second. On July 30th, 2020, Nintendo wins on a non-infringement motion. About less than 2 weeks later, Sony is precluded from even filing a summary judgment motion. And that case actually remains active in Delaware right now. They're in the middle of expert discovery. So I think what this really shows is the importance of the local procedural rules, the importance of the case schedule, because it can really affect the timing of your resolution, the nature of your resolution. And so you really need to be thinking about, am I in the venue that I want to be in, or is there something I can do to get to a different venue? And if you're a plaintiff or a defendant, those are really important considerations for different reasons. So I'm going to pause here to move on to the next topic, which is EULAs in terms of service. And so, the general principles here, EULAs in terms of service are set the terms by which players can use software. So anybody who's developing games knows that they'll have both of these or one or both of these somewhere embedded in their games. And there's different ways of setting it up. I'm just going to talk about 3 of them really briefly. There are click wrap, browse wrap, and hybrid agreements. Click wrap agreement, anytime somebody asks you to accept terms of service before playing a game, that's a click wrap agreement, provided that the terms are prominently displayed, you can see them, and you're asked to accept them by clicking your assent. That's a click wrap agreement, and it's a popular and generally enforceable way of presenting your EULAs in terms of service. Another way of doing it is through a browse wrap agreement, which doesn't require a click, but at least in the Ninth Circuit, is enforceable if a reasonably prudent user would have constructive notice of those terms. So if you display those terms somewhere where somebody is who's reasonably prudent is going to see them, then not requiring a click can be enforceable in Ninth Circuit. Third option is a hybrid. It's a little bit like click wrap, a little bit like browse wrap, but it can also be enforceable. Now, sometimes, even if you have a click wrap agreement, if it's too one-sided, that can sometimes be unenforceable, even if it's procedurally sound. We're not going to go into that today, but you should be aware that you can't just dump super one-sided terms into your agreements and expect that courts will always enforce them. So I wanted to talk about a couple developments in the world of EULAs in terms of service here in 2020. And so the first one arose in the context of a browse wrap agreement, and this is in the Ninth Circuit. Benson versus Double Down Interactive. And this was a pretty straightforward application of a 2019 decision, which also arose in the video game context, Wilson versus Huge, which was a first case in the Ninth Circuit to consider the circumstances under which the download or use of a mobile app establishes constructive notice of an app's terms and conditions. So in other words, you don't want to have a click wrap agreement. You don't want somebody to click to agree to something. You just want it to be automatic. What are the circumstances under which that will be deemed enforceable? So the Ninth Circuit considered that in 2019 and again in 2020. So here, the issue concerned an arbitration provision that was embedded in a browse wrap form in the game that was produced by Double Down, and some attorneys wanted to bring a class action suit and wanted to avoid arbitration. And so here, the court had to consider whether that arbitration provision was enforceable because it was present in that browse wrap agreement. So here the court considered the rule from Wilson and said, does a reasonably prudent user have constructive notice of this term? And so that depends on the placement and design of the terms and whether somebody playing the game or downloading the game will see them. So in Benson, at the time of the download, the terms of service were buried at the bottom of the page and accessible only after scrolling past multiple screens and images that the user did not need to view to download the platform for the game. So in that sense, it was not sufficiently conspicuous. Also during gameplay, the terms are obscured among brightly colored casino games, and so you couldn't see what was going on during gameplay either. Therefore, the court found that this was not enforceable. So that you could have an arbitration provision, but if you don't make it clear, you don't make it visible, there's a risk that it will not be enforceable, and so you'll be forced to litigate in court rather than your preferred venue. Another situation that arose this time in the click wrap form also concerned the enforceability of an arbitration provision in a EULA. This again came out of a lawsuit against Epic Games arising from in-app purchases during gameplay of Fortnite. The wrinkle here was, although the EULA was in click wrap form and so it required that assent and that's generally enforceable, here the issue was contracting with minors and then the specific issues that come up when you have minors playing your games and downloading and agreeing to terms like an arbitration provision, under what circumstances will courts enforce those? And so this came up in the Northern District of California. Again, this was a putative class action, and this was brought on behalf of a minor and an entire class of minors who claimed to have been misled about the refundability of some of these in-app purchases. And so the issue in California was that minors in California have something called the power of disafference. So what that means is under certain circumstances, minors can say, I'm not going to be bound by the terms of this contract, even though I agreed to it, and courts will respect that. And so disafference can be made by any act or declaration indicating an intent to disaffirm. Here, the specific disafference was done with a pre-suit demand letter followed by a complaint. So the same steps you would take, before initiating any standard litigation. The court found that was sufficient to allow the minor to get out of the terms of the EULA because that particular minor had stopped playing Fortnite after sending that demand letter. And so that it's not that you can just kind of keep using the service and claim to disaffirm the obligations. If you stop playing the game and you say, I no longer want to be bound by the terms, if you're a minor in California, you can do that. And so the court there specifically rejected Epic's argument that the fact that the minor had used his mother's credit card cut against disafference, that there was really a contract with the mother and not with the with the child. Court rejected that argument and allowed the minor to disaffirm the arbitration provision. So the takeaway here is that you may have a procedurally sound click wrap form for your contract, and it might have an otherwise enforceable arbitration provision in it. But if you're marketing to minors, you have to be aware that there's a risk that minor will be able to disaffirm that contract. And so you have to think through those risks when you're preparing those EULAs and thinking about how you're structuring consent provisions in your games, especially if you're marketing intentionally to minors and having in-app purchases that could lead to class action lawsuits. Now, I have additional slides here that deal with another concept that was raised by this decision. I'm not going to have time to kind of go through all these because it's quite a technical topic, but this Epic Games decision left some really attractive breadcrumbs for plaintiffs' lawyers who are thinking about bringing consumer protection lawsuits under California's Consumer Legal Remedies Act. And this is a little bit in the weeds, so I'll just very briefly introduce the topic. But essentially, California has a robust consumer protection platform, various laws that allow plaintiffs' lawyers to bring actions against defendants for violations of consumer protection laws. And one of them that's quite popular with plaintiffs' attorneys is the CLRA, because there's a fee shifting provision for successful plaintiffs. And normally the CLRA has been found not to apply to software because it's neither a good nor a service. But the court here rejected that view and actually said that there's some factual questions as to whether these in-app purchases did in fact constitute licenses for entertainment as opposed to services. And so what that meant was there's at least a possibility of future lawsuits targeting video game developers who have these in-app purchases, and that would expose video game developers to a more threatening form of class action lawsuit, because the CLRA has that fee shifting provision that makes it a pretty powerful tool for plaintiffs' attorneys. So again, we don't have time to go into all the nuances there, but this is an important topic. And if you're interested in discussing how those consumer protection provisions affect video game companies, I'm happy to do that. Although I'm based in Seattle, I'm actually licensed in California as well and practiced there for several years before moving to California. So happy to talk to you about this issue as well. And so the takeaways there I've already covered, and that's it. I'm sorry to go so fast. I want to leave time for questions, and I know we're getting near the end here. So anything that we've covered, by the way, is detailed in our Dorsey Legal Arcade newsletter, which I'm sure if I hadn't mentioned, Sarah or Ryan would as well. You can download all the cases we've talked about. You can download our analysis of those cases, and it's going to be, I think, emailed to you as well after the presentation, so you can take a look. So anything we've talked about, you can read about, you can read the underlying cases and really take a deep dive if you're interested in any of these issues.
Thank you, Stefan. Thank you, Ryan. And we're at 1:57 here. And as I said, we're going to take some questions and also continue to take questions past the hour. We do have one question that came in, Brian, Stefan, about, we've obviously focused on US law developments, but a question about really about content clearance, in-game content clearance for use by your game developer clients when video games are sold globally and are thus subject to IP laws in numerous jurisdictions. So just sort of the worldwide clearance and IP considerations where there's worldwide distribution involved. Would one of you like to weigh in on that question?
Sure, I'm happy to provide some thoughts quickly, and then Ryan, you can jump in if I haven't covered it. But one of the great things about Dorsey's platform and the way that our IP group is set up is we have contacts all over the world with local relationships, in Europe and Asia and Australia. And so if there's a specific issue that we haven't dealt with before, our IP team has trusted contacts all over the world, and they can kind of weigh in and resolve those issues efficiently. And so it's really pretty impressive, especially on the copyright and trademark side, how deeply connected our colleagues are with firms all around the world on those issues.
So obviously there would be sort of a non-US mindset with the international clearance considerations taken into account.
Yeah.
That's the only other question I see on the chat box, but please, if others have questions, please put them forward as we have time to answer them. Otherwise, you can feel free to reach out to any of us directly to ask any follow-up questions. You'll have seen in the chat box that there was a link to those who need CLE credit, and also to a copy of the presentation, which will also be pushed out via email. There will also be, as Stefan mentioned, some information about Dorsey's video game practice group's inaugural issue of the Dorsey Legal Arcade, where some of the developments today were discussed, as well as some of the cases that we weren't able to cover, such as the Epic and Apple decision. So with that, we thank everybody for their participation today, and look forward to remaining in touch as our video game group grows and remains active during this time.
Thank you.
Thanks, everyone.